Ricardo, and welcome to the Fazlaw Show. Most people do not know what to do or expect when faced with a legal dispute, be that in labor law, matrimonial law, debt counseling, property law, or more. For that reason, we aim to give our viewers a broad understanding of the law in South Africa to ensure that the vulnerable are not taken advantage of. In this show, we address specific questions aimed by yourself through our WhatsApp and our email platform that will be provided at the end of the show. So don't forget to send us your questions to ensure that your questions are answered. I'm your host, Fazluddin Abrams, and you're watching the Fazlaw Show on Cape Town TV. Today's episode refers or speaks to divorce, the dissolution of a marriage in South African law, which refers to the termination of a matrimonial union, the cancellation of legal disputes and responsibilities in that marriage, and the dissolving of the bonds of matrimony. That is, the two relationships between two parties who are married, be that in different marital regimes. This episode speaks to the preparation of the person who intends on divorcing their spouse, according to the Divorce Act 70 of 1979. It provides the viewers with important information to ensure that they are protected during that proceedings. With me today, we have attorney Ismail Muhammad, who is a litigation attorney with a passion of mediation and settling disputes out of court, but is not afraid to enter into court and battle it out in the interest of his clients. Ismail Muhammad is a legal practitioner who specializes in family law, evictions, debt recovery, dispute resolution, and general civil litigation. Ismail, thank you for being on the show again.
Thank you for having me, Fazlin.
So today's topic, divorce, which is a very difficult situation that people find themselves in, and it's a very emotional and hard process to bear. According to South African law, there are two types of divorces, meaning your contested and your uncontested. Can you explain that to our viewers, please?
Okay, Fazlin, the difference between a contested and an uncontested divorce is actually quite simple. It's in the words themselves. Let's look at the uncontested divorce first. Now, the uncontested divorce is, by its very nature, a simple divorce. That's when a husband and a wife, for whatever reasons between them, decide they no longer want to be married and they want the marriage to be dissolved, the divorce then to take place. They have no dispute as to assets. Either there are no assets of any value, or they've already decided she's going to take the house, he's going to take the car, the money is going to be split in a certain way. There's an idea as to how the children are going to be looked after, who's going to be the primary caregiver, who's going to have access and care of the children at certain times. If those issues have already been discussed and are in agreement, it's a simple matter of going to court, uncontested, and having that agreement made in order of court under a divorce order, and that's it. Divorce done completely uncontested. A contested divorce is the exact opposite of that. That's where either one or both of the parties wants to get divorced. There are assets and or children, and the parties have not decided who's going to get what. One party is saying, I paid for the house. The other party is saying, I paid more for the house. I'm entitled to the pension. I'm entitled to the movables, whatever the case may be. If the parties cannot agree, then it's up to the court to make the decision who's going to get what. And in that case, the parties need to go to court, and they essentially need to fight it out. They each bring the attorneys, or if they want to do it without attorneys, which is not necessarily recommended, they go to court, they put their relevant cases before the presiding officer, which might be a magistrate in the regional court or a judge in the high court, and then a decision will be made for them as to who's going to get what. And that is a contested divorce.
And it ultimately means that there's disputes, there's fights, and you also find that sometimes the parties end up fighting over an asset that is worth less than the time spent fighting over it, paying the legal representative.
100%. The unfortunate reality, as you correctly pointed out, this is a very emotional issue because this is somebody's marriage or two people's marriage. They've been together for many years, they said the I do's, till death do us part, and due to whatever reason, it's now falling apart. And that idea, that emotion that gets involved, does sometimes cause that people get held up on little things. I mean, an example is I once had a client.
Let's speak about that later.
Yeah, no problem.
We'll get to that. Just a quick one on now the law obviously prescribes particular evidence that needs to be presented in a court of law to confirm that there are sufficient reasons for a divorce to be granted, a decree to be granted by a magistrate or a judge. What are those specific? There's usually about 5 of them. Can you just explain them, please?
Yeah, let's just quickly just touch on that. Now, what we need to keep in mind is that the current South African law is one of a no-fault system. So previously, there had to be fault in order for a divorce to be granted. Now, because it's a no-fault system, any spouse can approach a court to say, I no longer want to be part of this marriage. And the court will allow the divorce to take place. However, when the court's looking at this, or in fact, even when individuals are looking at this, there are reasons that come forward. I mean, a simple reason which the court accepts is there's no longer love and affection between the parties. Right? Further to that, we have the classic example, which is infidelity. Then we have financial issues.
But infidelity is no longer a prerequisite for...
Right.
Right.
It's not a
Because some people might allow infidelity and they can reconcile.
100%.
So I think if one has to summarize it up, we're running out of time in this first particular segment, and I needed you just to tell me quickly 1 or 2 or 3 of them. So you've spoken about no more love and affection.
No more love and affection.
There cannot be a reconciliation at all. They've
No-
tried the reconciliation.
No communication between the parties.
Nah.
The not living in the same household any longer. Infidelity. Financial issues or a general change of lifestyle will all count.
So the court ultimately needs to understand that they've reached the end of the road, and there's no way that they can reconcile and move on.
Correct.
The only way for them to move on would be to grant a divorce decree, correct?
Correct.
Just quickly, reconciliation process. Can a spouse in a divorce proceeding insist on a reconciling attempt before the divorce can proceed?
No, not technically. Because remember, as I said, it's a no-fault divorce. So you cannot insist there must be reconciliation, but it's always advisable to attempt some sort of reconciliation or mediation before going to court and spending money and time getting the divorce contested, where it could have been uncontested or there could have been a reconciliation.
Okay. We've come to the end of the first segment. We have to go for an ad break. My viewers, we've come to the end, as you've heard. We will be going for an ad break. Keep watching for more answers to your questions. Welcome back to the Fazlaw Show. I'm your host, Fazluddin Abrams. In the first segment, we met our legal expert, our guest, Ishmael Mohammed. We also looked at the different types of divorces that we find in our law. We looked at the particular reasons that needs to be provided to the court in order for a decree to be granted. And we also looked at the question on whether a spouse can insist on reconciling with the other spouse before proceeding with a divorce process. So if you've just joined us, that's an update. Keep watching for more answers to your questions. I'm your host, Fazluddin Abrams, and with me today, a reminder, I've got Ishmael Mohammed. Thank you back on the second segment. Ishmael, I'm just going to jump into the next questions. Now, we've got various types of marital regimes, and there's quite a few. There's about 5 or 6 or 4 of them, 5 of them, and I need you to just, for the benefit of our viewers, touch on each one of them, and what is the effect of these particular marital regimes in a divorce process. But I also want to remind you, obviously I don't have to, but just for the benefit of our viewers, that we know recent case law has come and kind of like just throw the whole apple cart into disarray when it, before we would add a simple clean break principle on in community, and then out of community would have been quite simple.
Yes.
You don't and you can't apply for forfeiture and stuff. That has changed now.
That has changed now.
Right.
Okay, before we get into the change that's happened, let's look at what has remained the same.
Right.
Now, our default position in our law, when a couple goes and gets married, is in community of property. Now, what that means is any assets either party had prior to the marriage forms part of the estate of the joint marriage, of the marriage itself. That means that there's a 50-50 split on any assets, whether it be money, whether it be immovable properties such as houses, cars, pension funds, anything is now split 50-50, right? As well as debts. So if you owe the bank R1 million, now your spouse owes 50% of that money to the bank as well. That's in community of property. Out of community of property, there are two major ones that we look at. The first one we're going to look at is what is called with accrual. Now what that means is when you join into the marriage, before you say your I do's, you have a anti-nuptial contract registered. Now what that means is that you are now coming into the marriage with your assets and your spouse is coming into the marriage with her assets. And those assets you brought to the marriage are always seen as separate. So if you had a house and she had a house and you guys then get divorced, you keep your house, she keeps her house. However, any assets which you built up during the marriage, that will split 50-50 between you. That's the accrual. So you look at what you came with, what your estate grew by, you look at what she came with, what her estate grew by, and the difference in the growth is seen as your joint growth, and that gets split 50-50 between the two of you. The third one, and this is where the big change is now coming, this is out of community of property without accrual. So prior to very, very recently, we're speaking in the last few weeks now, if you were married out of community of property with no accrual, it means anything you brought to the marriage and any growth in your estate during the marriage was yours and would always be yours. The same thing for her. Anything she brought to the marriage or any growth she had during the marriage would be hers and would always be hers, and neither party could claim against the other person's estate or growth in their estate. That has now changed. It's very, very recently, the High Court has found that this is deemed unconstitutional because one of the parties might end up essentially getting the short end of the stick. What we find is often husband and wife get married, wife stays at home to look after the children, husband goes off, has a career, buys properties, pension, has everything there.
I want to cut you off there.
Yes.
Just in summary, what we're saying ultimately is that each case has specific circumstances that needs to be considered.
Correct.
And out of community or anti-nuptial contract without accrual is no longer a clean-cut
No longer clean-cut.
You have to look at this particular circumstances.
Correct.
Right. Then you're talking about religious and also your customary marriage. In summary,
Okay.
the consequences there.
Your religious and your customary marriages, you need to look at, number one, if you look at the customary marriage. Now, the customary marriage falls under the Customary Marriages Act.
Yeah.
Now, that act sets out that depending on the custom, if it falls under this act, you have to divorce in terms of that custom. Now, we have many customs which we do not have the time to get into each and
Let's
every one
focus
of
on the
them now.
majority of
So
our
you
country
would,
being
yes, you would
the
now
African
look at
Gulf
what
custom.
does the act say specifically on that. So it's not necessarily in or out of community property, but is deemed as a customary marriage, and that is how the divorce will take
And
place.
is considered in community of property or out of community of property?
That's considered out of community of property.
Depending on when you got married as well?
Correct.
Particularly. All right.
Correct.
Then we've got the religious and, which is considered Islamic and Hindu
Yes, now you
marriages,
have
right?
your religious marriages. Now, previously, religious marriages were not recognized. If you take the Islamic marriage,
So
for
are they
example.
considered in community or out of community?
They are considered out of community, right? But there is a duty of care that's always been there. That is changing as well. There has also been a recent case law on that, saying that it can be deemed a spouse, but again, you need to look at the circumstances.
Specific
And-
circumstances. So viewers
marriage.
take note, specific circumstances do apply to these marriages. It's best to consult an attorney before you decide on how to distribute your assets or your estates in a divorce proceedings. Just coming back to you quickly, we have to, we're running out of time, but we're talking about the forfeiture. If you can just summarize forfeiture for me.
Okay.
When can you apply for forfeiture? What is forfeiture?
Okay, forfeiture
And
is,
the requirements.
Yeah, forfeiture is when when two parties are married and there is a divorce. Now, generally, you're looking at some sort of a split of the estate. Forfeiture is when you're saying to one of the parties, you're not entitled to either anything in the estate or anything particular in the estate, a property, for example. And that is then, there's forfeiture of that to the other party. This is a very, very stringent thing, and this is only when there's been some egregious activity on the side of one of the spouses. For example, the couple's been married in
So
community
give me the
property.
requirements for forfeiture. We need to go to another ad break.
Well, look, let's just use a simple one, infidelity. If there's infidelity, then a party can go to court and say that there's been this infidelity and they are prejudiced and they need
Hold
the
on to
forfeiture.
that thought. I want to follow up with that. We've come to another ad break. Keep watching for more questions, your answers. Thank you. Welcome back to the Fazlaw Show. In our second segment, we had a quick recap of the first segment that was discussed. In the second segment, particularly, we had a discussion on the different marital regimes, and we touched on the aspect of forfeiture. We looked particularly at what forfeiture is, and we are about to conclude on the more particular requirements for forfeiture to apply. Ishmael, thank you. Welcome back again. So just to conclude on forfeiture, what are we looking at in terms of the requirements for forfeiture to be applied to a divorce?
Okay, very quickly, to look at forfeiture, we have to look at what the duration of the marriage is. We have to look at the prejudice that one of the parties is going to suffer should forfeiture not be granted. And you have to look at the conduct which leads to why forfeiture is being asked for.
And more particularly, I think the duration. So if
Duration,
you're married
as I said
for
first,
a month
duration
or
is very
week
important.
and you want a divorce, you wouldn't be able to share in the assets. That be it whether you married in community or out of community with a
correct.
Right. Just a quick one. Specific conditions where there are minors involved in a divorce proceeding, where the children born from the marriage are minors. What do that specific conditions
Okay, so
be?
what that does is that needs to go to the family advocate. Because remember, the High Court is the upper guardian of all minor children. So irrespective of what the parents decide in their divorce, the children are going to live with whichever parent or so on and so on. That needs to be put down into a settlement agreement, which needs to be lodged with the family advocate. This is an independent body.
To approve it, correct?
Yes, they look at it to approve, to say, yes, this does seem to be in the best interest of the children. They endorse that, and it can be made in order of court. If they don't endorse it, it needs to be changed, or they will give recommendations if necessary as to what needs to happen, because the children are deemed to be the most important aspect of this if those children are minors.
So now we come to the word liquidator. And liquidator, ultimately, I want you to just give me a definition of what or who that person is with regards to divorce proceedings.
Okay, generally a liquidator is someone that we find when we're dealing with liquidations and sequestrations. However, to summarize what the liquidator is here, when a divorce is happening and the assets need to split, but the parties cannot decide how the split needs to happen or what percentages need to go to whichever party, then a liquidator can step in to look at it from a financial aspect, to say, this is what person A brought to the marriage, this is what person B brought to the marriage, and this is the division that now needs to happen. And that's what our liquidator does in a divorce proceeding.
Just a yes or no answer. Can a person inherit, or a person who inherited an asset, would that asset form part of a divorce process?
It's not a yes or no answer. Generally, the answer is yes. If somebody inherits an asset, that asset forms part of their estate, and it can be split in the divorce.
So when would the answer be no?
The answer is no in two circumstances. Number one, if there's an antenuptial contract which says any inheritance a party might receive will not form part of the accrual. Or number two, if the person who died, if a parent, for example, passed away, and their will says this asset will not form part of any form of marital regime, whether it be in or out of community or property, then that asset is excluded.
Thank you. Just quickly to wrap up this particular episode, it's important that people understand in summary what the procedures are in dealing with a contested or an opposed divorce process. Can you explain that to my viewers,
To
please?
start at the very beginning, you first have some form of mediation. That mediation is either going to lead to a reconciliation, in which case the process then stops, or it's going to not lead to reconciliation and it's going to lead to the issuing of a summons. This is the first court document, which the wife might have served on the husband saying, I want the divorce.
Just step, it's fine.
Next one is the notice of intention to defend.
Yeah.
This is when the other party says, I don't agree with what you're asking for. She might be asking for forfeiture. She might be asking for maintenance, whatever she might be asking for. That's your notice of intention to defend. Thereafter, a plea is filed. He then is saying to the court and to her, this is how I think the divorce needs to happen. When that is done, we then move on to what is called a pre-trial. In the pre-trial, it's where the parties sit down and say, okay, we will or we will not fight about certain of the aspects that have been brought up. Then we move on to what is called discovery, which is everybody putting their evidence to the other person to say, this is what I will be bringing to court to argue my case. Then we go to trial, in which case evidence is led, witnesses are called, experts are called if necessary, and that then goes to the verdict, in which the court says, we find this divorce will take place under this conditions, and then the split is happened and the divorce is done.
Ishmael, thank you very much. I think that concludes the session
Thank you,
for
Fazlaw.
us. You've been an expert always, and I love the way you answer the questions. And thank you for being on the show, and we hope to see you back again.
Always a pleasure.
Thank you, my viewers. That brings us to the end of the episode. However, before you leave, don't forget to send us your questions to our email. That's info@fazlaw.co.za, or our WhatsApp number, that is 082 495 8989. The next episode that can look out for is, what do I do if I'm unfairly dismissed at the workplace? So please follow us on our YouTube, our Facebook, our Twitter, and Instagram profiles. The information will reflect on the screen. I'm your host, Fazlaw Abrams, and thank you for watching The Fazlaw Show on Cape Town TV.